Good evening. My name is LaQuitia Crosby. I want you to come on a journey with me. Imagine, if you will, a student who in a moment of frustration acts out violently at school. Can the school simply send that student home indefinitely until the issue is resolved? Well, today we're going to look at a landmark case that happened in 1988, which is Honig versus Doe. It was the Supreme Court case that answered this critical question, forever changing how schools discipline students with disabilities. Now, the main parties in this case was the respondent, which is John Doe. His identity is protected because he's a minor. And then we have our petitioners, which was Bill Honig, who was the California State Superintendent of Public Instruction, and other California school officials. Now, the court issue, the central dispute revolved around whether the school could exclude, suspend, or expel students with disabilities for behaviors that were related directly to their disability without specific procedures outlined in the Education of All Handicapped Children Act, which we know today as IDEA. I want to take you on a trip into this landmark case. Follow me as we look at the background of what has taken place. Let's get some background information. We have John Doe, our student. He's a 17-year-old boy who had been taunted, and in his moment of frustration, he reacted physically, attacking another student. Well, John Doe was diagnosed with EBD, emotional behavior disorder. Remember that. Okay, so in his moment of frustration, he attacked another student, he caused minor injuries, and while they were escorting him out, he actually kicked out a window. Bad, right? Okay, well, he was suspended indefinitely pending an expulsion hearing. We also have another student who is called Jack Smith. Now, Jack Smith is not featured in these slides, but he had a similar incident where he was also diagnosed with emotional behavior disorder. And after a wrestling match, he physically attacked a student after a wrestling match, and he was suspended indefinitely as well from school. Now, this is the school district argument. The California school official argued that they had an emergency exception under the EAHCA, which is now known as IDEA, allowing them to remove dangerous students immediately and indefinitely without any kind of formal hearing, citing safety concerns. Now, here's our legal question. Does the stay put provision of the EAHCA, now known as IDEA, prevent school officials from removing disabled students from their current educational placement for dangerous or disruptive conduct related to their disability? Follow me for more. What is the stay put provision? I am glad you asked. Now, in the EAHCA, it included a crucial protection known as the stay put provision. This provision stated that during the time or the waiting period of an administrator or judicial proceeding regarding the student's placement, the student shall remain in their current educational placement, meaning they cannot be suspended indefinitely while they're waiting on this hearing. Well, then the lower courts had their ruling. The district court ruled in favor of the students, so they issued an injunction against the indefinite suspension. Then we have the Ninth Circuit Court of Appeals, and it affirmed what the district court had already decided, stating that the stay put provision applied. and there was no dangerous exception. So the school board could not use that. They also highlighted the importance of manifestation determination. Now, manifestation determination basically says that if a student's behavior is a manifestation of their disability, you cannot treat this student like one of their non-disabled peers and just suspend them. What we must do at that point is to now bring the IEP team together, see how the IEP needs to be revised, and also now include a behavior intervention plan for this student. Now let's take a look at the Supreme Court's ruling and rationale behind their ruling. The Supreme Court had an 8-1 majority ruling. Now they affirmed the Ninth Circuit ruling that found that the stay put provision indeed prohibited the indefinite expulsion and suspension of a disabled student when the misconduct arose from their disability. Now, the court emphasized that the EAHCA's, which is known today as IDEA, language was clear, that it contained no dangerous exception to the stay put rule. The indefinite expulsion would effectively deny a student their FAPE, their free, appropriate public education, a right to a free, public, appropriate education. However, the court did acknowledge that a school needs to have something in place to maintain the safety of everyone. So, what could the school systems do? They could temporarily suspend a student for 10 days with permission, was permissible. The IEP team could come together. They would meet to discuss a change in placement and appropriate behavior intervention. Thirdly, seek an injunction. In truly extreme cases of dangerousness, schools could seek an injunction from the courts. How does this case impact special education today? Okay, well, let's look at the manifestation of determination. Manifestation determination. And remember, we talked about the manifestation determination is a review or a process that determines if the student's behavior or challenging behavior was a direct result of their disability. Now, you can either answer yes or no. If the answer is yes, that it is a direct result of their disability, the student cannot be expelled indefinitely. They have to either have a FBA, which is a functional behavior assessment, or they need to have a BIP, a behavior intervention plan in place. The IEP team can come together and develop this, or they can come and adjust one if it's already existing. If the answer is no, that the way that they behave had nothing to do with their disability, then the student can be treated like their non-disabled peer. However, the student still has to retain their rights. They still must have a free, appropriate public education. All right. What other impacts did this case have? Well, it limits on disciplinary exclusion. A student, it established that schools cannot stop providing educational services to a student with disability for behaviors related to their disability. Also, parental rights and due process. The ruling underscored the importance of parental involvement and due process. It safeguards in all placement and disciplinary decisions. And also, again, the emphasis on an FBA, a functional behavior assessment, and a BIP, a behavior intervention plan. The need to address challenging behaviors through comprehensive assessment and positive behavior supports became paramount. In other words, if we see that a child's behavior is a direct reflection of their disability, we have to have things in place. We must have a functional behavior assessment or a behavior intervention plan. If we see the student's behavior, how they reacted had nothing to do with the disability, then we can handle them like their non-disabled peers when it comes to expulsion or discipline, but they still have rights under IDEA. So we still must remember that we have to maintain their faith. Now that we've analyzed this case, how can we use these findings today? How can they be integrated daily? Well, here are some things as special educators that we can do. We can make sure that as special educators, we conduct thorough FBAs, functional behavior assessments, to understand why the behavior is occurring. And then once we understand that, we can develop effective behavior intervention plans to build positive supports. We can teach our students self-regulation skills, directly teach students strategies to manage their emotions and reactions before it escalates. Another thing that we can do as special educators is work closely with our general education teachers so that they can have an understanding of why these behaviors are occurring and what can they do to de-escalate behaviors before they get out of hand. We can make sure that we're involving parents, make sure that we have open communication with parents, talking about these behaviors. Also, as special education teachers, we need to know back and forth what the disciplinary procedures are for our school and for our school system. We need to make sure that we have those things ingrained in our minds so that we'll know what those students with IEPs, what does discipline look like for them. And also we need to make sure that we're documenting everything, putting data in place. We need to also, one of the things we can do is, I can't say this enough, as a special education teacher, advocate, advocate, advocate. We need to advocate for our students. When we are in IEP meetings and doing disciplinary discussion, special education teachers must advocate for understanding the link between a student's disability and their behavior. Because sometimes if you're not in special education, you may just think that a student is acting out, when actually what they're doing is a direct result of the disability that they have. So we need to make sure that we advocate for our students. Thank you so much for watching this slide, and I hope that this brought insight and gave you a look at what we can do as special educators. I think that this case was very important. One, it put in place things for students. No, it is not right for students to misbehave. It is not right for students to just bring chaos into a school. But we must understand that when students are acting out or when these behaviors are taking place, are these behaviors directed to their disability? And if they are, then it's up to us to make sure that we have things in place to help our students conduct themselves in a way where they can stay, one, in class, because being out of class and being out of school is not really beneficial for them. So we need to make sure that we have things in place to keep them in place. Thank you. Have a great day.